conservatory order that would have the effect of suspending any provision of the Constitution. You're being invited right now to do exactly what you have just told us cannot be done, and you're told the reason you should do that is because you're human and there is a possibility you're in error. Of course there is a possibility, my lord, you're in error, but there is a court that exists to correct errors made by this court. You're being asked to embarrass yourself to say just a few minutes ago that the conservatory order should not have issued in the first place, and then you're being invited to issue an order that would have the contrary effect. I think they are setting up the court for embarrassment. My lord, there is a reason there is a law which we all know, because both the people in the bench and the bar are lawyers. And it is common ground that no appeal operates automatically as a stay of any decision made by any court. The reason that rule exists, my lord, is so that whoever is desirous of an appeal can move the appropriate court, which they have done, and persuade that appropriate court we should that stay. So they are telling you, because there is a possibility you might be in error, therefore automatically, but the rule, if I understand it, is that no appeal, let alone an intention to appeal, can issue automatically. Lastly, my lord, you have been told about the Mazu paper, injunction. I thought we were talking about conservatory orders, my lord, because Munya told us injunctions are remedies in the realm of private law. They exist to protect personal private interests, and conservatory orders, which you just said cannot issue in the circumstances of this case, are the remedies available in public law for the ordered functioning of public agencies. And because, my lord, I said this court has jurisdiction, if eventually you find that the Honorable Brigadier Gachagua was not lawfully impeached, this court has still confirmed if he has a remedy, it can undo the entire process. Let us not detain you here, back and forth, flip-flopping, behaving like a peddler. It is holding the court at ransom, in my view.
My lord, if I use only 2 minutes in rejoinder, the court permit me.
You will respond after Peter.
My lord, I'll just take 2 minutes to mention something which will be in addition to our case. My lord, Article 10 of the Constitution outlines the doctrine of rule of law. My lord and my lady, the doctrine of rule of law anticipates that at some point controversies in the society, especially legal controversies or controversies related to the interpretation of the Constitution, will be determined by judges. And concomitant to that is the doctrine of finality of your decisions. And more importantly, the public policy in terms of consistency in judicial decision making. So, my lord, my lady, once you've made a decision, the expectation of the public is that you will stand by that decision unless there are exceptional reasons for you to depart from that decision. Especially immediately after you've rendered your decision, it will undermine that doctrine of finality of judicial decision making if you immediately depart from the decision without exceptional reasons. They have not put on record exceptional decisions to warrant that immediate departure, and the public expects that your decision will be enforced. Secondly, the doctrine of rule. We have listened to your decision, and we believe that the reason why conservatory orders cannot be continued is a heavy public interest reason of the need for the vacancy, for there to be no vacancy in the office of deputy. president. And the Constitution does not anticipate that. So, in conclusion, they, under the provisions of Article 164(3), they, based on the way the rule of law works to model the fabric of the society, they have the right to appeal. My Lord, you have granted that right in your ruling. And from where we stand, we submit that they cannot, on this matter of immense public interest, where you've made a decision for them to seek, to make an application from the bar, to upset a decision which you have rightly pointed out is meant to fill a major constitutional gap in respect of vacancy. And lastly, the right to be heard. The right to be heard is very central. Mr. Ndegwa has made factual statements in this matter in his oral application. Again, given the immense nature of this matter in terms of public interest connotations, it is important that the respondents are given opportunity to specifically rebut the factual questions of law, the factual questions and some of the legal points that they are brought up. So in that case, if they really want to move this court, then we will submit that the proper way is to make a formal application so that we are hard on that question. Thank you.
Your Lordship, the IEBC, the second application was directed at us. Everyone seems to have said something except the IEBC. And I just want to make two small points. Number one, as it relates to the application by Mr. Ochiel Dudley, my friend, first, Madhu paper was pre-2010 constitution. That is important for the court. It was a commercial matter relating to restitution. So it was a remedy in private law, not in public law. Madhu paper was pre-2010 constitution. It was a commercial matter, a restitution in private law. So this will not apply. The second issue, application by Mr. Ndegwa, Learned Counsel, I am looking forward to reading the decision of the court, because those were issues that we were on our feet for 30 minutes arguing about, the role of IEBC and what needs to happen. So already the court has made a decision on that, and likely the answer will be in the ruling that the court has already read. Third one, and most importantly, I want to point to the court the case of and two others versus the President of the Republic and the PSC, E084 of 2023. It is the CAS matter, and it feels almost like deja vu that Ochiel Dudley is here making this point. We lost that matter in the High Court. The court made a finding that the offices of CAS were not constitutional office. We were on our feet for a long time trying to urge the court to give us a Madhu paper injunction. And the court said, if the issue related to constitutional compliance or constitutional infraction, as the court has already noted, that the position of the Constitution must remain operational from the decision of this court, then that injunction will not apply. The remedy is for the parties to apply to the Court of Appeal for an appeal or a review of that decision. So those three things can clarify those two issues for the court. We think these applications are not merited, and the court and the parties should put more effort in their 5-2B application. Thank you.
Perhaps before senior speaks, maybe we get directions as to how many they are responding, because there was that limitation on this side, and we were restricted as the petitioners. If the court could give directions as to that.
Let Mr. Moses speak.
Thank you, my Lord.
My Lord, you have not given us directions as to how many of them should address you, considering that the petitioners were restricted.
We said two. 3 of them have already spoken.
My Lord,
Mr. Moses, nothing stops you from saying that you adopt the position of your predecessor.
That's correct.
Yes.
My Lord, I want to say that I associate myself with the sentiments by my colleagues, but I would want to add my Lord, that you have given a detailed and a very comprehensive analysis of your ruling. You've gone into graphic details and you have addressed various issues and given a determination on the same. We are not before this court, my Lord, to litigate in installments. My learned colleague, Mr. Ndegwa, has all along been aware that Professor Kindiki was nominated. For him to just spring up now and start raising issues concerning Professor Kindiki is just but a mockery of the justice system. My Lord, you've made a determination. You have thanked us official. We will not want you to reopen these proceedings again. They have known and available avenues to them. Let them proceed on those avenues. I submit, my Lord.
Thank you very much. On only one point, which I actually objected to when it was being made, the point was that how would Kenyans receive the decision? I'm not so sure whether this is what these applications should be based on, because whichever way, there will be parties that will be aggrieved by the decision. There are many others that will be satisfied. Do not be misled that there would be protests, just the way I also cannot mislead you by saying there will be jubilation and celebration everywhere. The position remains, the court has rendered itself in a decision, the court is thanked us, and therefore we have now to move on. Any party aggrieved knows what to do, which is either to appeal, apply for a review, variation, or whatever it is they have to apply for. If the processes that will take place after this would be contra the Constitution, every party knows what to do, and this court is still seized of the matter, and they will be coming over here for a pronunciation on what the constitutional rights are. Therefore, we should actually not be taking the route that the decision may be popular or unpopular. It's a decision of the court, and it cannot be challenged along those lines.
Thank you. My Lord, honoring the court and my colleagues' time, this is my rejoinder in exactly 2 minutes. My Lord, Rule 32.2 of the Mutunga Rules allows us to make this application informally as we make it. Rule 32.2 of the Mutunga Rules allows us to make a Madhu paper application as we do. It says the application can be made informally immediately after delivery of the judgment. Rule 32.2 Mutunga Rules. My Lord, this President, the Attorney General, when on the other side, has many times sought a Madhu paper injunction. In the Finance Act litigation, where my friend Mr. Somane was present, Justice Majanja presiding, this court in this room issued a Madhu paper injunction. My Lord, on the last point, my learned friend Mr. Ojenda sounds familiar with the Madhu paper case. It's a Court of Appeal decision. And you saw the first one, Bat versus Rent Tribunal. It is one of the most cited cases on the question of stay. And in that case, the Court of Appeal said, my Lord, allow me to read, and then I'll sit down. There is no inconsistency in granting such an injunction, a Madhu paper injunction, after dismissing the motion. The purpose of the order is to prevent the Court of Appeal's decision from being rendered nugatory, should that court reverse the High Court's decision. The respondents concede that you could be wrong. There's human infallibility. The purpose of the request we make is to respect that issue. What if you are wrong and you allow the wrong person to come into the high office you've just established? My Lord, allow the request for 7 days. Thank you so much, my Lord. And my Lord, may I just clarify clarify that our application is distinct. We do not seek stay, we seek an injunction. Thank you.
And I'm interested in the event, my lord, if it's allowed, can we also move you again to remove it?
My lord, I think in view of Article 50, they also have a right to make that application. Your Lordship, allow me to draw your attention to Article 149, Clause 1. That London is not burning, and that a vacancy is contemplated, and actually a vacancy of 74 days, within which due process ought to be initiated to ensure that a rightful person, fully qualified, fully known in law, fully appreciated by the law, takes over office. Therefore, this vacancy is a constitutional vacancy. Further to that, Your Lordship, permit me to address you that this is a new application and this application has not been determined. Further, allow me to indicate that I listened pensively to the three thematic issues that were raised by the court, and this is not one of them that was raised and resolved by the court. Finally, Your Lordship, we all have a duty to uphold the law and to defend the Constitution. On the 16th of October 1953, Fidel Castro had this to say in his defense, that history will absolve me. History will absolve the petitioners. That we have brought to your attention that you have the duty to protect the Constitution, that the person qualified should take over. I'll wait for the ruling. Finally, Mr. Somane has not addressed you on the qualification and the ability of a person to meet those qualifications under Article 99 and Article 137. He has not even told you that they are not applicable. If the court wants to say they are not applicable, history will absolve me. If the court wants to say that has no power to defend the Constitution, history will absolve me. If the court wants to pave way and mutilate this Constitution, history will absolve me. If the court wants to midwife an injustice, history will absolve me. I am most obliged.
My Lord, Sam Nyaberi for the ninth petitioner. Only two issues. I invite you to Article number 23 of the Constitution, which gives parties rights to come before you.
Article
23 of the Constitution, which allows parties to come before you to seek for reliefs. And in this instance, we are seeking an injunction by way of a stay, albeit temporarily, of the orders that this court has issued. And we are not seeking these orders in eternity. We are moving into the appellate court once we have the ruling. Number two, my Lord, I invite you to the application by the ninth petitioner, the notice of motion application dated 18th of October. Because there was an allegation that we have been sitting here and it's coming as news that Professor Kindiki has been nominated to take over the DP position. My Lord, that notice of motion application speaks to the application that we're making, that it was seeking for a conservatory order, and the court has rendered its decision. So we are inviting you kindly to exercise your discretion so that we may have that application processed before the appellate court if it is found of merit, so that we don't have to have it as an academic exercise. Thank you, my Lord.
May it please the court. My name is Dr. Iboso, and my co-petitioner had made a similar application that that the Honorable Court be pleased to stay the order that it has given today. And the respondents have raised an issue that Professor Kindiki was nominated over a week ago, and that if we were raising this application in good faith, then we ought to have raised it earlier. I wish to refer the court to its directions, which made it clear that one, the only applications it was going to hear were the 2 applications that were before the court, and this was made despite protests that my co-petitioner and I have raised for the last 2 weeks, that we have applications that seek similar orders and they've not been heard. However, I also would wish to direct the court to its own directions, which directed that we file amended petitions because many of the petitions had been overtaken by time. And if you look at our petition as amended, we actually raise concern about the process of election of the deputy president designate in our amended petition, and so it is quite in substance and whatnot. Secondly, I'd like to point out that my co-petitioner pointed out that we have been feeling discriminated, and as she explained earlier, she's dyslexic and sometimes she might rush her words, especially when she's tense. The feeling of discrimination that we've been having is that out of all the petitioners, we are the ones who have consistently for the last 2 weeks called on the court to refer to the applications that are before it, and that which touch on this, and we be given adequate time to ventilate them. Yesterday, I agree, we were given an opportunity to speak as interested parties, and after the respondents gave their case yesterday, I tried to catch the attention of the court and I was ordered to sit down. I wasn't rising because I don't have a right of response. I know that. I was rising because I sought the discretion of the court, specifically because there are specific 4 issues that the respondents raised against the things I had raised. And in the decision of the court today, which I have listened to, one of the issues has actually turned on that. The fact that this court believes, which I believe is wrong, that it has jurisdiction to reverse the assumption of office of the deputy president. Of course, you've given your ruling and we respect it, and we wish to appeal that ruling. However, now we are asking the court, because both the respondents and us applicants agree that we have moved the Court of Appeal, and the Court of Appeal has given a mention date. So the court is aware of that, or at least that is not disputed. We are asking the court to stay its decision today, allow us to move the Court of Appeal appropriately so that it can give the necessary orders as relates to that, even if it means correcting what we believe to be the wrong finding of the court. The idea that this court is functus officio does not arise, because the rules of the civil procedure, I'm not sure which rule exactly it is, allow any court, after giving its judgment, allows a party to ask for a stay even informally and the court to grant it. So really the issue of functus officio does not arise. Thank you very much.
Thank you. We will adjourn for 20 minutes. We'll be back at 5:30.
Kazi tu.
Yes.
They should have edited the topic.
A very historic afternoon as the High Court, the 3-judge bench, has paved the way for the swearing in of the the Cabinet Secretary and the Deputy President nominee, Professor Abraham Kithure Kindiki. That ruling coming in this afternoon, where the High Court has allowed Professor Kithure Kindiki to be sworn in as Deputy President, that the High Court has vacated the conservatory orders that were filed by the impeached DP Gachagua, and in that ruling issued by the presiding judge of the three-judge bench, Justice Eric Ogola said that the applications for conservatory orders are hereby disallowed. The conservatory orders on the 18th of October 2024 in the Kirugwe High Court are hereby discharged. That is the breaking news we continue to follow for you, even as this marks another historic segment, another historic step in the Kenyan political scene. Once again, the High Court has allowed Professor Abraham Kithure Kindiki to be sworn in as the Deputy President. The court has taken an adjournment and will be back at 5:30 p.m. to proceed with the proceedings, even as other matters continue to lie before the High Court as well as the Court of Appeal. We are taking a short break. We'll be back in a moment.